Well, good morning. It's almost time to start the meeting. And just to avoid any conflicts or long-winded conversations, I would like to offer a couple of observations and guidelines. One would be that this commission is meeting today to discuss and vote on the matters on the agenda, nothing else. And its prerogative to run this meeting is given to the president, and those decisions will be final. If you want to speak, please do. Speak up, be polite, announce your name, and tell us why you're speaking. And at this point, you have 2 minutes, and we will time that.
Why two?
Because we said so.
5.
2. When all else fails, go to rule number 1. The president is right. By state ethics code, you all probably know that commissioners cannot discuss any item on the agenda outside of an open and properly advertised meeting. So the commissioners are given an agenda ahead of time, and they can do their own research, probably to find what decision they would like to have on the items on there. So if you would all please stand, we'll have a prayer and a pledge. Most gracious and heavenly Lord, open our eyes to behold the beauty of your creation and all the blessings you have given us. May we be guided by your Spirit in the ways of justice, truth, and peace. Grant that we may always prove ourselves a people mindful of your favor and glad to do your will, and save us from pride and arrogance, and give us wisdom to do that which is pleasing to you. We ask for your strength that we may faithfully serve the duties of our office and promote the well-being of all people. Through Jesus Christ our Lord. Amen.
Amen.
I pledge
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
And this is the regular meeting of the Cabell County Commission on Thursday, December 9th, 10 o'clock. And the first item on the agenda is to approve the regular commission agenda.
Move to approve.
It's been
I'll
moved
second.
and seconded. All in favor signify by saying aye.
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 Next item on the agenda would be the minutes of the Board of Equalization meeting of October 14th, 2021.
Move to approve.
I'll second the motion.
Been moved and seconded. All in favor signify by saying aye.
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 Next item would be to approve the erroneous assessments, land consolidation, split tickets, probate documentation from the county clerk's probate office.
Move to approve.
I second.
Moved and seconded. All in favor signify by saying aye.
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 Next item is purchase orders, number 22-106423 through number 22-106603. Pay jackets and monthly payments to Fifth Third for fuel card purchases.
Move to approve.
I'll second the motion.
Been moved and seconded. All in favor signify by saying aye.
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 Aye, that is approved. We have 2 people who have registered to speak. The first would be Jan King.
Yes, sir. First, I'm Jane King. I'm from Salt Rock, and I'd like to ask 6 questions, and I have a short statement afterwards. And then hopefully I can get some answers to my questions. And when I'm referring to we, I mean the taxpayers of Cabell County. First of all, I'd like to know, how did we find or hire GeoWeb or LLC or Doug McKenzie when they do not even have a valid website? Were we aware that the same owner of GeoWeb / Doug McKenzie has been sued by several counties in West Virginia for not providing services contracted regarding mapping in the past? When when was this decision made and at what meeting to hire Doug McKenzie GeoWeb? Was the map based on current census? How much did we pay GeoWeb and Doug McKenzie? How many bids were submitted for that same process? Calhoun and Work County specifically has issues with inaccuracies with the maps. Calhoun Commissioner David Burr said, quote unquote, the mapping was out of kilter and just not accurate. This can all be found along with the other county suits and complaints in the Heard Herald.
If you're directing those questions to me, I don't have those answers. I think those questions would be directed, not in this meeting, as a matter of fact, to the county clerk. If Mr. McKenzie would care to answer any of them, that's fine. If he doesn't, then he doesn't. If that takes care of that, next we have Kimberly Herbert Maynard, who also has questions or has discussion on redistricting.
I'm Kimberly Herbert Maynard. I live in Huntington. And when the bids are submitted to the county, is there any type of background check, contacting of referrals, et cetera, before a decision is made on who gets dropped? I asked this question because Tuesday I spent about an hour and a half researching Doug McKenzie and GeoWeb LLC and gave Jim the information to research further. Now, if we can find this much information, out on one person by using public internet sites, why can't the county commission do the same? I'm sure you have access to more places to do research on people and companies before accepting their bid than I do. I, for one, is extremely sick and tired of elected officials making back alley deals with every Tom, Dick, and Harry that is not in the best interest of their constituents. Need I remind the county commission, you were voted into your positions by we the people, and you work for us. You received a paycheck because of the taxpayers of Cabell County. Just in the past year or so, the county commission sold, I believe it was 3 parcels of land in Ona for a fraction of the cost. However, you slung mud and was right down nasty to Carl and wouldn't budge an inch on the asking price at the airport after hundreds of thousands of dollars he spent cleaning up, repairing, remodeling, and addition of the airport cafe campground. At one of the meetings, I asked the county commission, so what is your hidden agenda? And I asked the same question today. What is your hidden agenda for wanting to remap the districts? Because I guarantee it's not in the best interest of those who you work for. If your hidden agenda is to keep a certain person from running in their current district, that is called gerrymandering. And when did the county commission get into the real estate business?
Thank you.
I will close by saying this. As a voting taxpayer for Cabell County, and since the current county commission has a history of zero competence to represent those who voted you into your position, I ask the 3 of you to turn in your resignation by 4:30 today.
Thank you.
I'd just like to say, Jim, that the redistricting is required by law.
Well, we'll cover that when we get to the item on the agenda, I believe, if that's okay.
Sure.
We now have bids to be open for the construction of the new sheriff's Ona field office and garage.
First bid we have is Landcore Builders LLC, 1027 Stewart Street, Milton, West Virginia, 25541. Phone number 304-390-4077. Their bid form shows the base bid of $1,556,700.
Did you say they're from Milton?
Yes. Second one is PJA $35,245. So, we've had a mandatory pre-bid meeting last month, and these are the two bids we received from the people. I think there were 11 contractors that showed up.
11 had pre-bid. We've answered numerous questions to those 11 people for the last 3 weeks, so we didn't have a two bid.
So,
Beth, what was the name of that company?
the last one is PJH
Okay.
LLC.
Give those to the sheriff for his study and
Yes, the sheriff and Chad will take a look at them, and the commission has the right to refuse all bids as well.
then we'll move on to the regular agenda. Item 21-12-09-277 is an interim report and recommendation of the Judiciary Commissioner regarding the estate of Jeffrey Eldon Paul.
Yes, sir. Thank you, Mr. President. I've reviewed Mr. Flesher's recommendations. However, I do not agree with his recommendations. And the reason being, he's recommending that the father be appointed as the personal representative of the estate during this interim period of time. And as you may recall from previous meetings, the will of the decedent specifically states that he does not want any living relative to receive anything. And then further, he says, not one dime of this money is to find its way to any living family member or relative, not to father or sister, and definitely not to my biological mother. So obviously, we're here to try to give credence to the wishes of the writer of the will. If the validity of the will is determined not to be valid, then of course the father would be able to do whatever he wishes, as whether he would want to serve or he becomes an heir. But at this point in time, until that will is determined valid or non-valid, it is my recommendation that the sheriff be appointed the curator of the estate, and by that his responsibility, which he has agreed to do, is to take under his management and maintenance of the assets of the estate, and to review any creditor's claims that somebody might wish to present, until such time as the validity of the will is determined, at which time he would then step aside. So it's my recommendation to this commission that we reject the report of the fiduciary commissioner, and in lieu thereof appoint the sheriff as curator of the state until the validity of the will is determined.
What's the time frame for that?
What?
What is the time frame for the validity of the will to be
Well,
determined? Typically.
the fiduciary commissioner will conduct a hearing. When we're talking about a holographic will, that's one that's written in the handwriting of the testator. There are three things that have to be done. It has to be in his writing or his or her writing. It has to be signed by him or her, and it has to conduct or set forth a testamentary intent of the testator. So those are the things I think that Mr. Flesher would try to determine, and Mr. Riker, who represents the father who's contesting the will, would then have the opportunity to present whatever he deems appropriate to determine that the will is not in fact valid. So that's my recommendation to this commission.
You recognize by the commission?
Oh, yes.
May it please the commission, I'm Paul Reichert. I represent Mr. Eldon Paul, who is the father of the decedent. To revisit this matter, I believe it was September 23, we were in front of the commission before. The commission determined there were two issues present and two issues they wished to both be referred to Mr. Flesher, your fiduciary commissioner. It was decided that was the best course of action. One was, what was the proper appointment of a personal representative over the estate? What should that be and who should that be? And number two, the validity of the will. Mr. Fleischer accepted the case, had a status conference. We participated to that point, even though there's absolutely no statutory mechanism for unqualifying someone who's been qualified as personal representative, absent due cause or some reason they've abused their authority. There's just no way to unappoint them. But we decided to participate and go along with the proceedings as the commission directed. Mr. Fleischer conducted that status conference and determined that Mr. Paul was in the best position to continue to exercise those powers. He was, after all, under bond. What's more important is the principal person who would benefit under this writing, which we have contested, is Ms. Kimberly Stump, who at that conference was present and had no opposition to the appointment of Mr. Paul. So now, for whatever reason, even though Mr. Fleischer was to make that determination, and he issued a written recommendation and prepared an order that would accomplish that by this commission, suddenly we find that Mr. Watson's asking this commission to reverse course and not do that. He still has, Mr. Fleischer still has the issue of validity of the will. Mr. Paul is under bond, just as he was on September 23. There's no statutory mechanism to unappoint someone, just as in the recent case of Dye versus Marion County Commission. The Supreme Court said you can't unprobate a will that you've had admitted to probate. You have to simply let the circuit court make that determination. There's no statutory means to unappoint someone who's been appointed as personal representative. I would ask that Mr. Fleischer's recommendation be accepted and that we proceed to whatever hearing is necessary on the validity of the will. There's just no basis for unappointing Mr. Waugh and to defy the recommendations of your fiduciary commissioner. That's what you said to do, and that's what he did, and that's what he recommended.
I would respond by saying that just because Mrs. Stump has agreed to it, she's the named beneficiary in the will, she has no authority whatsoever to determine what this commission does in the way of appointing a personal representative. The bottom line, and Mr. Paul, the father, he steps aside when he was appointed based on what had transpired in these meetings. And we go back to what this will says, and the deceased is saying under no circumstances does he want his father to receive anything. And if that's the case, and his father is now contesting this will, in other words, he wants it to be held invalid, and that's a direct conflict with what the writer of the will is saying. So my recommendation to you stands.
Has the validity of the will been proved?
No, that's to be done.
And if I may respond, that's one of the reasons why someone needs to be over the estate, and that's why Mr. Paul was qualified. As I said, there's no statutory mechanism to allow his disqualification without a hearing and a showing for cause. So he was appointed, he was bonded, and the only other active party to this case, Ms. Stump, has no opposition to that. Based on all of that, Mr. Fleischer recommended that Mr. Paul be appointed. The only person who's opposed to this is Mr. Watson, so far as I can tell, unless this commission adopts his point of view. Mr. Watson, as I understand, pretty much directed that this matter go to Mr. Fleischer. Now, Mr. Fleischer has made his recommendation. He's your fiduciary commissioner. It simply begs some sort of incredulity to determine what the problem is. We will proceed after this to a hearing on the validity of the will, but until we do that, there is no will. And again, your clerk's office qualified Mr. Paul, and he was bonded. So I would ask the commission to accept your fiduciary commissioner's recommendation.
It's interesting to note that on the report of Mr. Fleischer, on his signature page, he says recommendation approved, check mark, or recommendation refused, check mark. So he anticipated the possibility of either of those responses.
May it please the commission, of course, you can use your fiduciary commissioner. He has to give you the theoretical option to reject his findings, but that is a recommendation as your fiduciary commissioner.
If Mr. Fleischer's recommendations are rejected, the next step is,
To the appointment of the sheriff as curator of the will, so that the will, the assets of the will be maintained and preserved. Any actions that need to be taken can be taken on behalf of the estate by the sheriff as the curator. And that's part of my recommendation, that he
Okay.
appointed in lieu of the recommendation of Mr. Paul.
and if we reject Mr. Fleischer's, if we accept Mr. Fleischer's recommendation, what happens?
Then Mr. Paul would be appointed administrator of the estate in direct disregard to what the will says.
The will makes no statement as to.
The will says he does not want the father to have anything, do anything with the estate,
There's no
Mr.
statement,
Riker.
there's no appointment of a personal representative. You know that, Mr. Watson.
No, I'm telling you, I'm going by what this man said in the will.
May I speak to the validity of this will?
Yes. Tell us who,
If you go,
Eldon, tell us who you are.
my name is Eldon Paul, I'm the father of this decedent. If you go by the tone and tenor of this piece of paper, which I don't think is legal, that's why I challenged it, you would think that my ex-wife and my daughter and myself are terrible people that didn't care one iota about my son. That could not be further from the truth. Over the years, my ex-wife had given my son thousands and thousands of dollars. My daughter gave him thousands of dollars. At the time this piece of paper was written, the date on it, he was recovering from a back surgery, and I was paying all of his living expenses that at that particular time totaled $78,000. A couple days, a week after this piece of paper was written, I gave him another $3,000 or $4,000. All total, it was over $100,000 I gave him while he was trying to recover. That's why I don't think this will is valid. I don't think that either two things, he wasn't in his right mind, he was under undue influence from the heavy medications that he was taking, or he was under influence of some person. I don't know. But my ex-wife, my daughter, and myself had done nothing but bend over backwards to help my son. So he couldn't even spell his last name right when he wrote the thing at the end of the will. That's why I don't think that it comes close to being legal.
And I understand that, and that's what Mr. Riker's responsibility would be when he has the hearing before Mr. Fleischer, if in fact what you say is proven to be true and the judiciary commissioner agrees with you and then would hold the will invalid, he would make a recommendation to this commission that he thinks the will is invalid based on the evidence presented to him. And if that's the case, then the will would not be valid, and then consequently what is stated in it has no bearing, which would then allow you to step back into the picture. That's all we're waiting to see is the validity of the will.
What is the outcome final if the will is invalid?
It becomes an intestate estate, in which case the parents are now deemed beneficiaries of the estate, and Mr. Paul would be, and he could be asked to be appointed as the administrator of the estate and go forward as they would like to do now.
Is it appropriate to ask the value of the estate?
We don't really know for sure. There was a life insurance policy which has not been revealed to us, the amount of it, or whether it's valid and who the beneficiary is and so forth. But there's also, as I understand it, a lawsuit pending, and as to whether that becomes valid or not, or something the estate receives. So we don't really have, unless Mr. Riker can inform the court otherwise, as to what he thinks the value of this estate is.
May it please the commission, we do not know of any lawsuit. One life insurance policy that maybe existed during the late Mr. Paul's lifetime probably does not exist now and has lapsed. We would still be investigating as to whether there were any other life insurance policies and what they may be worth. Mr. Paul, my client, therefore went a bond in case such assets did materialize. So if I may just encapsulate this and narrow it down, I don't think Mr. Watson, I know Mr. Watson can't quote to you any law or authority that allows you to unappoint an appointed personal representative of the state without it being a hearing and for just cause. If that's done totally outside the parameters of law, there shouldn't have to be a need to go to the circuit court for writ of prohibition and a writ of mandamus, which could award us attorney fees and some costs. We should just proceed the way Mr. Fletcher, your fiduciary commissioner, recommended. That will allow us to allow him to get business done under his bond. We'll proceed to the fundamental hearing about the validity of the will as he foresaw in his recommendation. It's the only course that makes sense and is consistent with provisions of law. So we would ask you to, in fact, ratify Mr. Fletcher's recommendation and let us proceed.
If in fact you make a decision to reject Mr. Fletcher's report, then like Mr. Riker says, which he doesn't want to do, he can go to the circuit court and appeal your decision.
Are there obligations of the estate to be taken care of?
May it please the commission, there was business being done after Mr. Paul was appointed. There's mail that's been received. He of course froze and didn't open any mail after he was quote unquote revoked and his appointment rescinded. I've told him not to take any action such as that. Now, there's no validity, there's questionable validity now about whether he can make investigation about assets that may exist. He's had to basically stop in his tracks. So that's not getting done. We don't know if it would bear fruit or not, but it's not getting done because his appointment is definitely under this cloud. So if you ratify Mr. Fletcher's opinion, he'll be able to pursue that again, be under bond so that even if he loses his position under the will, he will be protected for anything he could possibly misdeed in any way. So that's why it seems to be an incredibly obvious conclusion on what to do.
The curator, the sheriff, can do exactly the same thing, and the sheriff doesn't, he's already bonded as a sheriff, so there's no concern about that as well.
What's the time frame if we reject the commissioner's opinion and they time frame to get back to where they want to be?
Well, the order would state that the commissioner's report is rejected and in lieu thereof to appoint the sheriff as curator, and that would take place immediately. Then it's up to Mr. Riker if he wants to challenge that in court.
My question is, by rejecting the fiduciary's recommendation to the commission, does that delineate from the standard of practice typically?
What?
Does that delineate from the standard of practice typically?
No, because
By
he's
rejecting that.
indicated, I mean, he, the fiduciary commissioner, realizes that you have the authority to go either way. Normally, we do not have a situation where we normally would reject the fiduciary commissioner's recommendations. However, this will, and what Mr. Paul says may very well be true. I mean, all the money is expended on his behalf and so forth. We don't know that. All we know is what is in this will and what the writer of the will said.
I would like to move that we accept the recommendation of our attorney, Bill Watson.
Any further comments?
I do.
I don't know that you probably can, in the terms of your office so far, look back to a position where you rejected a fiduciary commissioner's recommendations. And this is something, Mr. Fletcher's well aware of the options. Mr. Paul, again, is bonded. He is a relative, immediate relative and would be an heir at law of the decedent, but he's bonded for anything that might go wrong. To simply say that doesn't matter, or we're going to appoint the sheriff, is completely at odds with legal standards and precedent. I again urge us, the commission, not to make us do unnecessary measures in defiance of recent Supreme Court decisions and the absence of any authority for the steps Mr. Watson would like you to take. Again, I would ask you to consider that, please, as you vote.
Well, I think we have the authority to do so. It's just whether it's been the standard practice, since I've been here, it's not been the standard practice, to reject the fiduciary's recommendation. However, I mean, trying to decide the determination of estates has been really one of the most difficult, jobs here as a commissioner, because we're dealing with family members and I mean, not my family, but I tend to go with the intentions of the deceased. What does the deceased say in their will? What was their desire? Now, I know in this instance, there hasn't been a determination of the validity of this will. And that's something that's going to be determined hopefully in the near future. I can understand your point of view, and I know it was a recommendation by what you say of the fiduciary commissioner. However, what would be the harm of a third party such as the sheriff serving as curator until we can determine whether it is a valid will or not?
Commissioner Snowden, you have the sheer power to reject your recommendations from the fiduciary commissioner. That's obvious, and that's why you put,
Exactly. Yeah, I
that's why you
understand
put the yes/no blank in the form. What I was saying is under Supreme Court standards, once there's been an appointment made, there's no vehicle without some sort of just cause for misperformance of duties to unappoint them. There's no mechanism for that. That's what I meant by there's no standard law to do that. That's only a circuit court decision at that point, unless there'd be hearing that he somehow violated his fiduciary duties. Absent that, there's no mechanism to do it. That's why we're saying with him having been appointed, having been bonded, it's not only appropriate that he go through with it, there's no legal standard to say, there's no lever to pull anymore for the county commission to take it away from him without just cause. And a hearing on that.
I understand.
Are we taking it away from him, or are we merely postponing or withholding, as opposed to taking away, that power from Mr. Paul?
Commissioner Morgan, he was appointed.
Right.
He was appointed. And so there's no mechanism to unappoint him. Now, if later down the road, there's some reason to change fiduciaries over the estate, that can be done, but only for just cause.
So-
And even if this will is admitted to probate, it did not nominate a personal representative. That may happen down the road, but once this appointment's been made, there's no such thing as being able to rescind the appointment or unappoint someone. That option, as I said, like the lever, isn't there to be pulled anymore.
He keeps referring to just cause, and the just cause is the language of the will.
I disagree.
I know you disagree, but that's my feeling.
I understand your feelings.
Okay, and that's my recommendation. There is a motion on the floor.
Well, I have another question before we obtain a second on that motion. What was that court case that you mentioned, Dyer versus?
Dye versus
Dye.
County Commission of Marion County. Mr. Ansel Ramey made me aware of that case. It was just decided, if I'm not mistaken, in September or October of this year. Now, it talks about the inability to unprobate a will. But my point is, it's the same thing, once the appointment of admission to probate of a will or the appointment of a personal representative is concerned, there's no will left to unappoint without a hearing that he's guilty of some sort of misfeasance of office. But it's Dye versus County Commission of Marion County.
We have a copy of that, and Mr. Ramey indicates that it's not applicable to this particular matter.
Well, perhaps Mr. Ramey should be here to speak to us on this. You provide me with the opinion, that's, you're free to read it. But it's always good to see people read authorities. That would be great.
Is there a rush, a need to make this decision today? Obviously, we are not attorneys. We have two known attorneys. One says this, one says that. It would seem to me that I would think that maybe we need a third opinion to see if it goes either way, other than Mr. Fleischer also. If it's, if a,
There is mail, there are checks, but I don't know if anything's about the stale date, if it takes that additional time to study this.
Well, we meet on December 21st.
we do.
And we could take that time to seek out additional information. I mean, obviously you wanna make the right decision when it comes to, cases like this.
Well,
So, but we have a motion on the table.
no, we have a motion on the floor to refuse the recommendation of the fiduciary commissioner. If it's not seconded, it would die for lack of a second. Is there a second to the motion? Hearing none then, I would suggest that we put the item on the agenda for December 21st. I'm just trying to be careful not to say anything that screws up what we're trying to do. Is that appropriate? Can we?
Yeah, what I would suggest, if that's the situation, is to put it on the agenda for our next meeting and have Mr. Ramey here, because you're looking for a third or another opinion, and let him reflect what he thinks is the right decision.
Well, the original motion to reject dies for lack of a second, so do we have any other motions concerning this item number 277?
No, it doesn't require a second. You didn't provide a motion, but I would like to ask our council to provide me with the Dyer versus Marion County
I have
case,
it
so I
right
can be
here.
looking at it in the next few weeks.
So then, is there a motion to table this item and take it up on December 21st?
I'll make that motion. I'll make that motion.
I'll second it. All in favor signify by saying aye.
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 Then we will see you gentlemen on December 21st.
Thank you very much.
The next item is item 278, harm reduction program for the Cabell County Health Department.
Jim, I'd just like to say I can't hear very well. I don't know if
Okay.
you can fix it, but I'm not hearing people very well.
We'll work on that, or we'll speak louder.
Okay, thanks.
Okay. Item 278, harm reduction program, Cabell County Health Department.
Ms. Cartmel, can you hear me from here? Should I move closer?
Come
I
right
can
up.
hear you.
Okay.
Well, I'll come closer. Be sure that as the commissioners are aware, the West Virginia State Legislature passed a law this year that requires licensure for the operation of syringe service programs like the one that we've operated in Cabell County since 2015. I appreciate all the time that the commissioners have taken to study this issue and the educational session that I hope answers your questions. We believe that this law creates a new level of accountability for our program. We welcome it as an opportunity to show our citizens that we meet or exceed statewide standards in our operation. We're here today to ask for your support, which is required for us to continue to operate this essential portion of Cabell County's comprehensive and successful efforts to address substance use disorder in our county. Thank you for your consideration.
Is there a motion to,
Well, I have a few questions. Mostly, I mean, just so that the public can be made aware of, I know we had some conversations about this in the past, but, there was a in 2018, in July, the Herald Dispatch ran a story, and it was when law enforcement under, Hank Dial, had some concern about the needle litter exchange in the community. And there were some changes that were made, and it's, so the participants would be required to return syringes to receive new ones, in an effort to reduce litter syringe. And that they, the participants would receive the same amount in syringes as those returned. Has that been actually happening? Because it's my understanding, based upon the information that we get every month, from the health department on harm reduction, that they're being weighed. It's like all of the needles that are brought in, whether it be in a kiosk, maybe put forth by diabetics, or whether they're participants in the needle syringe exchange program, how are they counted? What is the current practice, and then how would that change under this legislation?
I think our current practice is to count rather than weigh for individual service encounters. We still weigh our syringes because we have to weigh our waste in accordance with the laws of handling infectious waste like syringes. But the actual individual encounters occur on a visual count.
So like say if I'm enrolled in the program, which I think there's, what, 900, was there 900 participants?
We estimate about 900 participants.
So say I'm signed up for that program and I go in and I'm gonna, what's the process? Just, is it, like I go in, I sign up for it, what happens if I'm enrolled in the program?
Do you want the process then, or what's going to happen?
Well, what are the changes? And with the legislation, what's going to be the difference in practice for those enrolled in the program?
We believe, we are not sure how the models were reviewed as far as making the rules to enact this statute, but we believe that our program was used as one of the models, and we anticipate very few changes.
So what about the unique identifiable, the legislation provides that each program that is approved has to have a uniquely identifiable syringe that is unique to that program. What is from the, and I'll obviously show you a picture. This is where I had gone around with a community member in some of the drug houses, and you'll see the needles that are around. So how would they look different than what's given out now? How would they be uniquely identifiable?
Our syringe program distributes only one brand in two sizes. And so we're fairly certain, and we've surveyed other pharmacies, we're pretty sure that we're the only ones giving out that syringe. And if it's not one of that brand in those sizes, then it didn't come from our program. Certainly, regardless of where it came from, if it's littered in the community, we collect it.
So the ones at the Health Right in Charleston, I had toured that program as well, and they barcode specific to the client. And so say they're given 40 needles or whatever, it's attributed to that client and it's documented. And so if there's a needle that's left, a syringe that's left in the community, they can attribute it to that person, and then they get warnings. And if they don't comply, there has to be some type of level of, you know, I mean, you have to be able to follow the rules to some extent, but they can attribute that needle that was littered in the community, whether it be a park or a school or a neighborhood, and they can say, well, you know, you're not being responsible, so you're going to be on probation. We're not going to give you any more needles until you can show us that you can bring in needle for needle exchange. So how are you going to do that when say a client comes in and they just bring in needles that aren't barcoded or attributed to that? Like how is that going to take place?
We have a specific policy by which we address issues of people coming back with fewer syringes than they gave us, and we address it individually with them. Barcoding is one of the approved methods of identifying syringes to the program, but we've not been able to determine a manner by which we could barcode and maintain the infection control standards that are required, and we would also see that as an onerous increasing cost. So we've adopted a different standard, and it does meet the standards of the statute.
But it seems like Health Right in Charleston can do that without it being a burden on them.
I can't
mean-
speak to Health Right. I don't know how they do that, and I don't know what their burden is.
Your, the proposed program that you're asking us to approve does meet the standards that the state health department has recommended, correct?
We will not receive a license unless we meet the standards established by OFLAC.
Okay.
Okay, my last question, I guess, would be, so I'm hearing you, you're not going to just weigh them, you're going to count them, so it's gonna be, client comes in, you give them 40 needles, when they come back, you're gonna count 40 needles?
We're going to count.
And then if they don't bring in 40 needles, they still get the bag of needles, new needles? Or how does that work?
We have a policy that establishes how many they will receive based on how many they bring back.
Okay, so that's a written policy, or will
Yes,
be?
it is.
Okay.
And it will have to be approved by OFLAC before we receive licensure.
Well, there's an article in the paper recently in the Herald Dispatch, trying to see the date of it, November 18th, and it says that there's been a 62% increase in fatal overdoses in the state. And I would think that, you know, you have a harm reduction program. Well, yeah, this might address the HIV aspect of it, you know, because the HIV is costly to treat or whatever. But it doesn't diminish the fact that more people are dying. So if the program is successful and you're bringing people in the hopes of getting them treatment, I mean, how does that correlate?
That states West Virginia statistics. Cabell County has actually improved in its overdose deaths since 2017. Well, I think we peaked in 2018, but certainly between that time and 2020, we reduced overdose deaths in our county substantially. And that's largely because of the comprehensive effort, not so much from syringe services. Syringe services itself does nothing to reduce overdose other than to be a touch point for naloxone distribution, education, and entry into recovery.
Are you aware of this? I found a study, it was done by the Department of Economics, Vanderbilt University, and it talks about, or syringe exchange programs helpful or harmful, new evidence in the wake of the opioid epidemic. And the study was quite lengthy, and I've got a copy of it, but it talks about how they found that SEP, which is syringe exchange programs, decrease HIV diagnoses up to maybe 18%. But they present new evidence that the syringe services increase rates of opioid-related mortality and hospitalizations, suggesting that needle exchanges alone may be less effective than other interventions. Has there been a study done to see what the hospitalization rates are for other non-HIV illnesses or problems associated with intravenous drug use?
I'm not aware of the article that you're citing. As far as in Cabell County, I don't think we have a study that specifically addresses admission to hospital in relation to this. We have evidence regarding entry into recovery. We have evidence in regards to willingness to enter recovery after overdose. We also have evidence of improvement in addressing a very large HIV outbreak, but I don't think we have that hospital admission information.
Although we talk about needles all the time, there are, as you just stated, I think, other benefits of the program of needle exchanges, of being able to get people into various programs, that sort of thing, and reduce HIV, possibly.
Yes, it is, and certainly the actual needle aspect of it is its most misunderstood component. But as a touch point, as a place where people will go to receive public health intervention or even health care, especially linkage to care, either for hepatitis, for HIV, or for substance use treatment. The syringe service program is that essential touch point. And even though it's a very small part of the whole comprehensive effort, that's its essential nature. That without it, we don't have as successful a comprehensive program.
Now, the last question would be, in the September report, it said that, that's from the Cabell Huntington Health Department, the 13 new client visits were in the exchange program. 904 were return client visits, and it serviced 333 individuals. I'm assuming that the 333 came maybe 3 times in the same month. But 18 were tested for Hep B, C, HIV, sexually transmitted diseases, and TB. So out of those visits in September, it doesn't seem like there were a lot to be tested. What's the process for testing, and can they opt out? Is it required? Like, say, we're going to give you free needles, but you're going to get tested so that we can know that you're not spreading it to the community. Does that take place?
Yeah, the testing is opt-out for new clients. We test new clients unless they refuse the testing, and they have the right to refuse.
And what about the ones that are return clients?
We test on we try to test every 3 months. If we get them every 6 months, we're pretty well satisfied. The standard is to test once a year.
And so can HIV be spread only through clean needles, or, I mean, it can be spread other ways, correct?
HIV is spread sexually or through injection and sharing of infected injection equipment.
And we're assuming people living in these drug house conditions aren't participating in other ways of spreading HIV. I mean, they can still get it, right?
Yes, our goal is to eliminate all HIV transmission.
Well, my vote's going to be no. It's evident that I understand the reason why public health wants to do this. You know, I mean, there's a mindset that it could reduce the transmission of HIV, but I know of other communities and counties that don't, and they still have drug use, and they're still not having outbreaks. I mean, that the information, I mean, that may change. But one of the reasons why I'm really kind of discouraged is I had asked for an audit of the Cabell Huntington Health Department of the needle exchange program, because to me, information is power. You need to be able to make good decisions based upon information that you receive. And the people of Kanawha County were able to have DHHR audit their syringe service program, and they subsequently had to close down because if you look at the recommendations on that, it just wasn't done right. And I'm not sure how the Cabell Huntington Health Department program differentiates from the one that was closed down in Kanawha, but we don't know that because we didn't have that ability to have the evaluation and the audit of the program itself. I'm not talking about a financial audit. I'm talking about an audit of the program itself and how it operates and is it successful. I think that the citizens need to have those answers, and so that was rejected just to get an audit, and so until such time, I'm not going to lend my support. But I do appreciate the work that you do. I think you all done a great job with COVID and keeping our food supply safe.
As they say, is this a
Okay.
question or a speech?
Well, you can
May
call
I-
it what it
May I
is.
respond?
Yes.
I understand that you're disappointed that you did not receive an audit. This puts us under OFLAC, and there is a method for requesting a review from OFLAC of our program, and you will be able to receive. That's why I say this makes us more accountable. And if this is passed, and if we become licensed, OFLAC will address those issues.
I would like to move the approval of the request from the Cabell Huntington Health Department that they are seeking in its licensure of the syringe service program to comply with licensure requirements enacted by the West Virginia Legislature in 2021. I so move. Is there a second?
She says she lost us.
Hello?
Hello, we lost you, I guess, huh?
I noticed.
Sorry
You were
about
just
that.
gone.
I made a motion that Grace might be able to read back to me.
You made a motion, what? I'm sorry, I didn't get that.
Well, I was going to ask Grace to read it, but it was that the commission approved the request of the health department needs to seek licensure of its syringe service program to comply with the licensure requirements enacted by the West Virginia Legislature in 2021.
Okay, I can second that motion.
Okay. We've had discussion, lengthy.
Right.
Then in that case, the question is on the approval of their request. All in favor signify by saying aye. Aye.
Aye.
And any opposed?
No.
The motion passes to approve their request. And next we would have on the agenda, item number 279, placement agency engagement letter for the potential insurance of revenue bonds by the Cabell County Commission of Cabell County. Is that,
That's part of the bond,
This is on the 10-year,
yeah. the
Right.
bond-
Which-
Bond issue.
which they're actually not moving forward with at the moment, but they
Right.
wanted to go ahead and get the engagement letter signed.
Right. And I would recommend that we do that.
And I move to approve.
Second?
been moved and seconded, all in favor signify by saying aye.
Aye.
We have next on the agenda, item number 280, resolution of the Cabell County Commission in a matter of adoption of the proposed precinct changes within Cabell County.
I would move to approve map number 1, which I think divides us into 3 districts.
You're too soon on that. This is the precincts.
Oh, we're on the precincts now, okay.
Right. Is there a motion to approve the adoption of the proposed precinct changes?
Yeah, I would make that motion as well.
But the precincts need to match the magisterial districts, correct? Or no? Okay. Because I thought we'd be putting the cart before the horse. I'll second that.
It's just the way it's on the agenda, and we'll get there.
It'll run again, this one will run again next, on our next agenda too, it has to run twice, so.
Okay. All in favor of the adoption of the proposed precinct changes signify by saying aye.
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 Next is the item number 281, resolution of the Cabell County Commission in the matter of establishment of precinct locations within Cabell County. And some of them changed.
Just very few, I think, Marie read, Center, wouldn't let us go back there, so we had to find it.
Do I
And I
have,
so move.
we have a motion
Second?
and a second? All in favor signify by saying aye.
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 The resolution passes concerning the precinct locations. Item number 282 is a resolution of the Cabell County Commission in the matter of establishment of county executive committee districts. That would be Democratic and Republican executive committees.
I have a question for Phyllis. Was there
Shoot.
input by the county executive committees from both parties, or, I mean, are they aware of those changes, or?
Well, the Democrats had a meeting, I think, and we supplied the information to them. I've not heard from the Republicans regarding it. I mean, it's done up by population. So, I mean, we can't let other people, and he has to figure what's the proper amount of people.
Oh, I understand
within
that. I
5%,
just
so-
wondered if they both, had any input
No.
or looked at it or had
No.
any.
Haven't heard from him other than I know the Democratic Executive Committee asked for it.
Is there a motion to establish the districts for the county executive committees? If not, I will move that we approve that resolution.
I'll second it.
All in favor signify by saying aye.
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 Next is the resolution of the Cabell County Commission in the matter of adoption of the realignment of the magisterial districts of Cabell County.
I so move. Map number 3. I think it's the first map, but it's divides us into 3.
I think that's map number 1.
Right.
I will second that.
Well, I think,
And now, Kelly, go ahead.
well, how does that work when we have two, this is a question for council, we have two maps before us. I know like some of the counties, had like 8 maps to consider. So how does that work in order? I mean, if you have one that just comes up and 2 are gonna vote for it, then that doesn't give an opportunity to discuss both of those. So should there not be an explanation of both maps that are before us, and then we can make that determination based upon the information provided?
I would think, because I remember earlier you were talking about a 5 magistrate.
Well, we're under 5 now.
Yeah.
We're under 5, and I think maybe, I haven't looked back, I couldn't find it actually, but to see how long we've been under 5 magisterial districts, but you can have anywhere in code between 3 and 11.
Right.
So the
10.
5, is it 10?
10.
5 and 10, so we're right in the middle.
10.
Yeah, we're in the middle, sort of, by having the 5 magisterial district component. So I thought we should have discussion on both maps before you all just throw one up there and vote on it.
You're on the floor.
But we already have a motion to adopt one over the other, and we haven't had that discussion.
Well, I'm suggesting if you wish to have a discussion, have it.
Yeah, that, with your request to me, I would think that's appropriate if you want to discuss a different map, then the floor would be yours.
The,
Who has the floor?
the whole issue of the maps, was brought about by an act of the United States government called the census. After the census, every 10 years, maps are redrawn. And anybody who does not realize that the drawing of maps has created some conflicts within various states and other places hasn't paid much attention to that. This county got their information basically in October and needed to wait until the state had decided, the Senate and the House, where their boundaries would be because of not being able to cross delegate lines and that sort of thing. They finished their work, I think the Senate did, on October the 25th. There have been some questions asked as to why we did it. We did it to bring the county into districts that are of plus or minus 5% equal population, and as near as possible into equal land size. A comment was made at some time, not by the commission, suggesting why not try 3 districts. A 3-district map was drawn by Mr. McKenzie. There has been a question as to what Mr. McKenzie's qualifications and talents are. Maybe not talents, but Mr. McKenzie's qualifications. He's a graduate of the University of Kentucky with a Bachelor of Science in Civil Engineering and Mining Engineering, a registered professional mining engineer, a West Virginia real estate broker, and also holds the distinction of being licensed to fly remote planes for observation, I guess, and mapping purposes. Mr. McKenzie lives in Summersville. He did the mapping for Cabell County after the 2010 census. And the maps that were drawn because of several things. One was Cabell County lost 2,619 citizens, population less that much between 2010 and 2020. And from the western end of the county, 2,987 persons moved from the western end of the county to the eastern end of the county by precincts and other methods of counting. That left an imbalance of 10% in a couple of the districts. A larger portion of Cabell County's population still is in the western part of the county, and there's no way to get around that because that's where Huntington is. And with the exception of some population as you go up the interstate, the rest of the area north of the interstate and south of the interstate in the eastern part of the county is sparsely settled. So therefore, when a map was drawn, the three-district map was drawn, which met the qualifications of what the requirements are. The three-district map preserves political education executive committees, which we just talked about. The Board of Education finds that it's most suitable to them. In the three-district map, there will be a Cabell County Commissioner living in each district. And as far as the Board of Education is concerned, there will be a member of the Board of Education from each district. As it is now with 5 districts, whether it be a commissioner or the Board of Education, there can be 2 districts that have no representation directly by a person living in that area. The maps are drawn basically on reasonable guidelines using natural divisions and highways and various things. So it's easier to figure that out. And by the time frame that we had to work with, 30 days notice, public notice, and then taking it up at this meeting, we now are at this point of having a 3-district, and Commissioner Sabanya asked for a 5-district map, which was drawn and has been on display, as has the 3-district map, in the clerk's office for 30 days. The motion was to approve the 3-district map. If you would like to say something about the 5-district map, go right ahead.
Well, I mean, you are correct. Cabell County's population has decreased from 96,319 down to 94,350. And there has been a population shift to the eastern part of the county, and we have lost a congressional seat. And this is going to be the first election, I guess, in history of the state where we'll have 100 single-member district delegates, where you don't have multiple member delegates representing a certain pocket of the county. So it is going to be a lot of information to process, by the voters, because they're going to have, changes in their legislative delegation and the number of delegates that they have. They're going to have changes in their precincts and where they vote. So there is quite a bit to consider, and that's kind of out of our power. But at the same time, we do have the determination to make as an elected body to run our magisterial boundaries. We have always operated, from where I can find, under a 5 magisterial district scenario. And, we have the 5-member now, or the 5 magisterial now. We have 3 members of the county commission. I know Wayne County just recently changed theirs from 5 to 4. They still have 3 commissioners, but they elected to keep more magisterial districts than what they have commissioners. But, you know, the thing is, like, when I went to run for, and this has nothing to do with politics because, you know, it's a map. But at the same time, when you go to file for a county commission seat, you have, currently under Capital County, under 5, you can have people, candidates coming from 3 different magisterial districts. It doesn't have to be from that one magisterial district. So you can have more people running for office in the scenario that we have now, under the maps we have now. And so if we adopt a 3-member district, even though the magisterial districts grow larger, it still limits people to be in that one little magisterial district if they seek to run for public office. As I said before, you know, I think Logan County considered 8 different maps. In Fayette County, they had multiple map scenarios, and we here have 2 that we put out for public comment. I'm not sure how much public comment we received. It wasn't, you know, overwhelming. But I don't know what motion's on the table. I'd like to make my own motion to have a 5-member district. But I do have a question, either to our council or maybe the clerk. We received on our listserv from the Association of County Commissioners a communication at the end of November, and it was forwarded to us, and it was from Don Kersey, who's I guess the counsel for the Secretary of State's office. And he said something. He said, because your county clerks and staff, many of your county commissions are redistricting magisterial boundaries to account for the population changes reported in the recent census. In those counties, prospective candidates for county commission or county board of education have asked many of you whether they reside in the open district for the upcoming 2022 election. Unfortunately, this issue is not settled. The Attorney General's office is reviewing the law and relevant cases now. They are in the middle of preparing for oral argument before the Supreme Court of the United States in December, so their opinion may not come until January. Are you aware, either of you, of an open district by which has been moved to the Supreme Court for that determination, since the maps have come in so late and you have people who already want to run? Is that taking place? Are you aware of that?
The
Anybody?
current incumbents reside in appropriate districts, and the time frame to file for office is January the 10th is the opening date for that.
Mhm.
So I don't see that whatever point you were making is a point to be made.
Well, that part of the communication mentions prospective candidates to the county commission. Down
Right.
further in that, it talks about a case of Burkhart versus Sign that pertained to the sitting county officials, and if they were moved out of the magisterial district, they could still serve out their term, even though they didn't live in that current magisterial district. They would have to answer to that at the next election. So I think those were 2 different.
I don't think they have an answer on it. I think that's gone to the Attorney General's office, and there's no answer on it yet.
Okay, but we should have something like that. And
I don't think we have the issue,
Well,
because we have incumbents living in the districts.
but that doesn't just pertain to incumbents, it pertains to prospective candidates.
Well,
I was just wanting to get that clarification, because that is something that's in the court, I believe, correct?
I was told it was with the Attorney General's.
Place, so just help me understand the pros and the cons.
it seems to me that the balance of population and the equal areas represented, as well as the fact that whether voters understand or not, that there will be a representative from each of those districts, whereas now, as we well know, 2 in the commissioner's race are always vacant or allegedly non-represented. And I just believe 3 would be easier to work with.
We do have to recognize, though, that all 3 commissioners, regardless of the magisterial district from which they come, represent the whole county. Like it's not like legislative
That is-
districts where you just, well, you represent your little, only the voters of that respective delegate district can vote for you. Everybody in Cabell County can vote for the commission.
That
so
is true, and I
doesn't-
suppose you also know then that the map that is actually on file in the Secretary of State's office has 2 of the current commissioners living in the same district.
That wasn't my act. I don't think
And
it's
I'm not
anybody's
one
act.
of them. There is a motion on the floor, I believe,
It's been seconded.
and been seconded to approve map number 1, which is a 3-district map.
I would like to move my map first.
Okay.
Okay. Because if you all adopt yours, then I'm not gonna have an opportunity for a vote on mine.
I would think, though, you have to have a vote on the district, and if it didn't pass, then the next would be the fire. In other words, I think you have to vote on the motion that's on the floor.
All in favor of the motion that is on the floor, which is the adoption of the realignment of the magisterial districts of Cabell County into 3 districts, would signify by saying aye.
Was there a
Aye.
second?
Aye.
Was there a second?
Yeah, there was a second.
No.
Motion passes, resolution passes. Next is item number 284, a letter from Irv Johnson saying he's done a good job. Additional compensation for Cabell County Assessor's Office.
I'll move to approve.
Been
I'll second.
moved and seconded. All in favor signify by saying aye.
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 Item number 285 is another letter from Irv Johnson, Cabell County Assessor, regarding the dog fund and the payment of $30.10.
Move to approve.
I'll second.
Been moved and seconded. The resolution is approved. The letter is approved. Item number 286 is a resolution of the Cabell County Commission in the matter of a resolution authorizing the signing of a grant contract between the West Virginia Courthouse Facilities Improvement Authority and the Cabell County Commission for repairs to the clock tower facade and domes.
Good news.
How much money?
The grants were $100,000, that requires
Project
a
only.
25% match from the county.
It's much needed.
It is much needed.
Yeah. I will move to approve.
We have a motion to approve. Is there a second? I'll second. All in favor signify by saying aye.
Aye.
Aye. Next item is number 287, a resolution of the Cabell County Commission regarding state budget revision number 5.
This is a state revision. This is reimbursement on salary money for law enforcement. We also had to move some money around into the state computer network budget because of their billing from last year. They're just not getting caught up on their billing, so we didn't get billed appropriately. So it caused us to be over budget, or under budget, so we had to move money into that. And then also this revision is, the last revision moved the CARES money into Fund 1 that the commission had decided to use on the new buildings for law enforcement, which the CARES money was reimbursement for law enforcement salaries. And this now is moving the money out of Fund 1 into the capital improvement building fund.
Is there a motion to approve the resolution?
Move to approve.
And a second? Second. I'll second that. All in favor signify by saying aye.
Aye.
Aye. Next item is to place on record other documents to be recorded. Letter from Comcast, price changes as of December 20th, 2021. Monthly statements of assessor, Cabell County, West Virginia for the month of November 2021.
Move to place on record.
Been moved. I'll second. All in favor signify by saying aye.
Aye.
Aye. After the signing of the appropriate documents and other signatures, we will stand adjourned. Is there commissioners' representation reports on good and welfare and for Cabell County? If not, you're welcome to stay while we write our names. Otherwise,